miscellaneous E 2037 as the fourth respondent in this ruling. So on the 30th of May 2025, the respondents were presented in court by a miscellaneous application filed on the 29th of May 2025, where the applicant sought to detain the respondents at Capitol Hill Police Station for a period of 15 days to enable the investigating officer, who is Inspector Nicholas Njoroge, to complete his investigations. The application was premised on the grounds that the applicant was carrying out investigations of kidnapping with intent to murder, which is contrary to section 258 of the Penal Code, creating disturbance in a manner likely to cause a breach of peace, which is contrary to section 95 9b 1b of the Penal Code, and giving false information to a person employed in public service, which is contrary to section 129a of the Penal Code. The application was supported by an affidavit by the IO, wherein in paragraph 36, the IO gave his reasons for wanting the respondents detained in police custody pending investigations. The first and second respondents were represented by learned counsels Mr. Kirago, Mr. Mageto, and Mr. Nyamo. The third respondent was represented by counsel Mr. Wainaina and Mr. Chacha, while the fourth respondent was represented by counsel Mr. Mushiri. The IO relied in his supporting affidavit in its entirety and urged the court to allow him detain the respondents for 15 days to enable him obtain medical records and record a formal report from the victim, who was currently hospitalized at Karen Hospital in serious condition, and further that he required the respondents to assist him in tracing and arresting the other suspects. The IO also stated he needed to subject the electronic gadgets recovered from the respondents to forensic examination. And lastly, the IO stated he wanted the respondents detained for their own safety until the ground was neutralized, since the incident had sparked public uproar. Mr. Kirago made an application to have the IO subjected to cross-examination on the context of his affidavit, and the court allowed the application, and subsequently the IO was cross-examined by the different counsels for the respondent. On cross-examination, the IO told the court he had already recorded statements of the respondents. He also confirmed he had taken away their electronic gadgets. The IO maintained he needed the respondents detained in view of the four reasons given in paragraph 36 of his affidavit. The IO, however, confirmed that the respondents did not work at the hospital and they had no role in the preparation of the medical reports. The IO stated he did not know if the respondents had any control over the victim. The IO confirmed the respondents' freedom will not prevent him from recording the witness statements. He also confirmed that it was not only police who could arrest citizens, but also the respondents would assist in the arrest. The IO confirmed that the electronic gadgets were in his possession and he wanted to subject them to forensic examination. The IO, however, confirmed the respondents did not play any role in the forensic examination. The IO stated that he wanted the respondents to remain in custody until the ground was neutralized. He, however, confirmed none of the respondents had reported a threat to their lives. When questioned about the letter from the ODPP, which was dated the 29th of May 2025, the IO confirmed that in paragraph 5, the ODPP had approved the charges as reflected in paragraph 2 of his affidavit. The IO confirmed the victim was a sitting member of parliament with police protection. The IO stated he was not aware if any of the respondents were serving a custodial sentence or if they had breached any bail conditions before. The IO maintained the respondents were arrested on the 28th of May 2025 and not the 27th of May 2025. The IO, however, acknowledged there was a press release issued by the Inspector General of Police, and in the press release it spoke of the statements being recorded from 5 individuals, but he maintained those were different people from the respondents' hearing. The IO also confirmed that the Inspector General had stated the victim's statement was not taken since his family had protested due to his ill health. The IO denied there being a political motivation in remanding the suspects in custody and maintained that his objective was not to send a message to the opposing party, and he denied forum shopping since initially the respondents had been taken to Kahawa Low Courts. The IO told the court the third respondent was arrested in Zimmerman area on the 28th of May 2025 and not along Kenyatta Road on the 27th of May 2025. The IO, however, confirmed he did not give the third respondent a chance to consult with his counsel. In submissions, Mr. Kirago maintained there were no grounds to hold the respondents in custody as investigations are being conducted. Counsel enumerated the instances where suspects can be remanded as envisioned in section 36A5 of the Criminal Procedure Code and told the court the IO had confirmed the respondents were not serving a custodial sentence. None had breached a bail condition before. The IO counsel submitted that the respondents could be contacted through their counsels to go to the police station if required and urge the court to uphold the rights of the respondent as guaranteed under Article 49(1)(h) of the Constitution, and relied on several authorities, among them the authority of Republic versus Odero and Republic versus Gibson Kiplagat Bet. On his part, Mr. Onena submitted that the IO was not coming to court with clean hands, and he did not therefore deserve the order sought, since he had lied to the court. The respondents were arrested on the 28th of May 2025, when in fact they were arrested on the 27th of May 2025. Mr. Onena told the court there were no justifiable reasons advanced by the IO to warrant the detention of the respondents, and denied that the third respondent's life was in danger. Counsel submitted that the third respondent was a family man with 4 children, the youngest being 2 years old, and a businessman, and his physical address was known. To buttress these submissions, Mr. Chacha told the court that when the third accused was arrested, he was held incommunicado, forcing them to file an application for habeas corpus at the High Court. Counsel also accused the IO of forum shopping, since the whole of yesterday they had spent the day at Kahawa locals, and when the IO could not obtain favorable orders, it's when the respondents were brought to the Milimani courts. Mr. Chacha accused the IO of political witch hunt and urged the court to protect the political space by releasing the respondents. Mr. Moshiri, for the fourth respondent, submitted the application before the court, was politically motivated, and urged the court to grant the fourth respondent reasonable bail terms. On the part of the prosecution urged the court to allow the application by the IO to allow the IO conclude his investigations. The prosecution maintained that the court had the powers to grant the order sought as envisioned under Article 49 as read with 36 of the Criminal Procedure Code, which gives court powers to detain a suspect for a period not exceeding 30 days, and in this case the IO was seeking for 5 days to conclude his investigations. The court has well considered the evidence of the IO for wanting the respondents detained in police custody for a period of 15 days, as well as the applications by the counsels for the respondents to have the respondents released either unconditionally or on pre-charge bail. And Article 49(1)(g), the Constitution says that an accused person has the right at the first court appearance, among other things, to either be charged or to be informed the reason for the detention or for the continued detention, or to be released. In Section 36A of the Criminal Procedure Codes, it provides an investigating officer may make an application for pre-charge detention supported by an affidavit detailing the reasons why a suspect should be detained. The question therefore to be answered in this ruling is whether the state has demonstrated compelling reasons to warrant the continued detention of the respondents. And Article 49(h) of the Constitution, it entitles every accused person the right to be released on bail or bond on reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. This being the case, it's clear it's not an absolute right, and it may be curtailed if there are compelling reasons. The duty to demonstrate the compelling reasons rests on the prosecution. In the case of Republic versus Dansan Muguya and Kasim, that is Mombasa Criminal Appeal number 26 of 2008, Justice Ibrahim held that I do hold that if the prosecution objects to the release of an accused person from detention, at the first instance, the burden should be on the prosecution and not the accused to prove that, or at least demonstrate the existence of compelling reasons. In the case of Republic versus Pates Gishovi, the court, while expanding the duty of the prosecution, stated, further, in my view, where the state opposes bail on account of the often cited and commonly known fears, which includes the likelihood of the accused person absconding or interfering with witnesses, it must step out of the realm of imagination and speculation and provide the court with persuasive argument backed by facts and experiences and circumstances unique to each individual that will make the court appreciate the need to deny an applicant bail. In the present case, the reasons advanced by the prosecution, as reflected in the affidavit sworn by the IO for wanting the respondents detained, is that the IO needs to obtain medical records and record a formal report from the victim, who is currently hospitalized as Karen Hospital in serious condition, and further that he requires the respondents to assist him tracing and arresting the other suspects. The IO has also stated he needed to subject the electronic gadgets recovered from the respondents to forensic examination. The IO has also stated that he wanted the respondents detained for their own safety until the ground was neutralized, since the incident had sparked public uproar. And lastly, the IO inferred that if the respondents were released, they would interfere with the investigations. The court will therefore examine these grounds exhaustively. So on the first ground, that is the need to obtain medical records for the victim and record the victim's witness statements, the IO has given the need to obtain the complainant's medical reports and record his witness statements as one of the reasons he needs the respondents detained. However, on cross-examination, he confirmed the respondents do not work at current hospital and are not in any way involved in issuing the victim's medical report. In respect to the recording of the victim's statement, the IO confirmed that the reasons the same had not been done as reflected in the press release issued by the Inspector General of Police was that his family had protested due to his health problems. The IO admitted that even if the respondents were released, it will not stop him from obtaining the report or recording the statement of the victim. On the second ground, that is the need to subject the electronic gadgets to forensic examination, the IO has stated that he needs to subject the electronic gadgets to forensic examination as one of the reasons for wanting the respondents detained. The IO, however, confirmed that the said gadgets are already in his possession and the respondents do not work at the forensic lab or play any part in the examination of the gadgets. On the third issue, that is the respondents to assist the IO to trace and arrest other suspects who are still at large, the IO has stated that one of the reasons he wants the respondents in custody was so that they could assist him trace and arrest other suspects who are still at large. When questioned by the defense, the IO confirmed this assistance was in form of information. This begs the question, will the information given by the respondents differ if they're in custody or out on bond? I opine not. The respondents can still report to the police station if required to give more information. Further, as admitted by the IO, the witness statements of the respondents have already been recorded. I do believe whatever information the respondents may have in respect to this case is already contained in their witness statements. Number 4, the safety of the respondents. The IO has stated he wishes to have the respondents detained for their own safety until the ground is neutralized. The IO, however, confirmed there were no reports made by any of the respondents of threats to their lives. None of the respondents have been targeted by any members of the public. The public outcry, therefore, that the IO is talking about seems to be nothing but a figment of his imagination. It is ridiculous that the IO will be more concerned about the safety of the respondents more than they are. I do believe if any of the respondents felt their lives were in danger, they would wish to voluntarily remain at the police station even without the IO suggesting it. On witness interference, on the issue of witness interference, the IO has stated that if released, the respondents may interfere with investigations and witnesses. In this case, apart from the victim, no other witness has been disclosed. The victim herein is a sitting member of parliament with full security detail. The IO has not disclosed how the respondents would interfere with his evidence. In the case of Republic versus Asbel Kiprop Malel, that is 2014 EKLR, the court observed that the laid down test was that there should be a definite allegation of tampering or attempted tampering with witnesses supported by proved or admitted facts showing reasonable cause or belief that such interference will cause an injustice to occur if the accused was released. In the case of Republic versus Dwight Sarai and 4 others, the court stated that for the prosecution to succeed in persuading the court on this criteria, it must place before the court material which demonstrate actual or perceived interference. It must show the court, for example, the existence of threat or threats to witnesses, either directly or indirectly, incriminating communication between an accused and the witnesses, among others. In the present case, apart from the IO merely stating that the respondents are close associates of the victim, no other evidence was led to this effect to reach a conclusion that if released, there will be witness interference. There has been no demonstration that the respondents have reached out to the victim and tried to influence, threaten, or intimidate him in any way in respect to his evidence. In this case, I do believe that the IO has not demonstrated any compelling reasons to warrant the accused person's continued detention in custody. The court notes that when granting bail, it entails striking of a balance of proportionality in considering the rights of the respondents who are still presumed innocent at this point, and the need for bail is to assure that the respondents will appear for their trial and not corrupt the legal process by absconding or interfering with the witnesses. Under Section 123A1 of the Criminal Procedure Code, it provides for the factors to be taken into consideration in determining an application for bail, such as the nature and seriousness of the offense, the character and antecedent of the accused person, the defendant's record in respect to fulfillment of previous bail conditions. The same considerations are replicated in the bail and bond policies published by the Kenyan judiciary. In the bail and bond policy guidelines, in page number 9, it states that bond or bail amounts and conditions shall be reasonable given the importance of the right to liberty and presumption of innocence. This means that bail or bond amounts and conditions shall be no more than necessary to guarantee the appearance of an accused for trial. Accordingly, bail or bond amounts should not be excessive, that is, they should not be far greater than is necessary to guarantee that an accused person will appear for his or her trial. Under Section 36A(5) of the Criminal Procedure Code, it clearly states that the court will not detain a suspect unless there are compelling reasons to do so, such as the risk of witness interference, if he's serving a custodial sentence, if he's a minor, if there is a risk to his security, or he has earlier breached the conditions of his release. None of these conditions have been demonstrated by the IO to warrant the court to deny the accused person's pre-trial bond. So, having weighed all the factors, I am satisfied there are no existing compelling reasons to have the respondents detained in custody. However, the court cannot ignore the fact that the likely charges facing the respondents are serious, and there is need to ensure that investigations are not jeopardized. Accordingly, I will grant the respondents pre-charge bail, but on the following conditions. Condition number 1, each respondent shall be released on a bond of 1 million plus one surety of a similar amount. In the alternative, each respondent may be released on a cash bail of 300,000 with 2 contact persons. The respondents are barred from communicating with any of the witnesses, either by themselves, their agents, or their proxies. The respondents will report to the investigating officer weekly or whenever summoned to the police station until the court otherwise directs. And lastly, the prosecution may be at liberty to apply for the cancellation of the bail terms granted to the respondents herein in the event they breach conditions 2 or 3 which are stated herein above.
The motor vehicle KDG 803 is still under the detention at the PCI headquarters. I pray that since the IO and vehicle be released to operate, the vehicle belongs to the Cyrus here in the
Yes. Yes. I believe that cuts across board. All the councils will be supplied with a copy of the ruling. So I believe we can have a mention date. Since the IO had requested for 15 days, maybe we can have it mentioned within the next 15 days so that we can confirm where they are at. If the 17th of June is convenient for mention.
It is.
Mentioned on the 17th of June to confirm the status of investigations. If any of the respondents are unable to meet the bond terms, they'll be remanded at Capitol Hill Police Station. In view of the sentiments by the prosecution that the motor vehicle is still an exhibit and still under investigations, we can have the application for release made at a later date once investigations have been completed.